Hi everyone, welcome back to the channel. Today I am going to cover a case which is personally one of my favorite case laws. This is the case of Hussainara Khatoon versus State of Bihar 1979. Now, before going to the case, let me give a small background about it. In the year 1979, Indian Express published an article about the report conducted by the National Police Commission. In the year 1977, Sir R.F. Rustam, who was one of the members of the National Police Commission, visited Patna Central Jail and Muzaffarpur Jail, where he conducted a survey through which he found that a large number of prisoners are in jail without a proper trial. According to him, the convicts have served for an extended period of time than that the actual length of their imprisonment. Now coming to the facts of the case. The news article on Indian Express motivated activist and lawyer Pushpa Kapila Hingorani to file a public interest litigation. A habeas corpus petition was filed in the name of one of the prisoners named Hussainara Khatoon. She was a Bangladeshi national and was detained in protective custody for 4 to 5 years, even after when the government declared that the prisoners held under Foreigners Act of 1946 should be released. Mrs. Hingorani brought attention to the denial of prisoners' right to a speedy trial and the issue of long-term detention without bail. Despite expiring their detention without being granted bail, the detainees are comprised of men, women, and even children. Because of the lack of understanding of the court's procedure, the hearing is rescheduled every time they are presented before the court. Now coming to the issues. Issue number 1, whether right to speedy trial is a part of the Article 21 of the Constitution of India. Issue number 2, whether free legal aid under Article 39A must be implemented despite being a directive principles of state policy. Argument by petitioners. In the counter affidavit, it is stated that the right to a speedy trial is a fundamental right. The direction of the court, many prisoners who are currently on trial are located both in Patna Central Jail and Muzaffarpur Jail. The police decision to remand the prisoners to judicial custody after multiple presentations before the magistrate is unfair and unreasonable. As per Article 21 of the Constitution of India, the right to a speedy trial and the right to life are violated. The Supreme Court of India issued an order to the state of Bihar to make a report on the under trial prisoners, but the respondent did not take the order of the Supreme Court of India into consideration and no one appeared on behalf of the state. Now coming to the judgment and observations. It was a division bench comprising Justice P.N. Bhagwati and Justice D.A. Desai. According to the judges of the Supreme Court of India, the main cause of poor people's lack of justice is the highly unsatisfactory bail system. The system is hampered by its property-oriented approach, which seems to suggest that the sole deterrent against fleeing from justice is the risk of monetary loss. The Supreme Court of India declared that the detention of these prisoners were unlawful and in violation of Article 21 of the Constitution of India, which grants the right to life and liberty. Justice P.N. Bhagwati explained the grounds for consideration and advised on the factors that need to be considered while granting bail. These are the following. 1. How long has he been living in the community? 2. His financial credibility is a result of his employment status, history, and credibility. 3rd, his familial connections and ties. 4th, his reputation, character, and monetary condition. 5th, his criminal record. 6th, identify a responsible person who can confirm attendance in court when required. 7th, nature of the offence he is charged for probability of conviction. And 8th, low or no risk of intentionally disappearing. The accused will be released on personal bonds if the court finds the grounds to be satisfactory. The court stated that if the accused is granted bail and fails to appear before the court for the hearing, then his bond will be forfeited, resulting in the bail being denied in the future. Article 21 of the Constitution of India, which stipulates the right to life and liberty, has been found to be a more comprehensive concept by the court. The court also refers to the case of Maneka Gandhi versus Union of India. In this regard, to speedy trial, the Supreme Court has instructed that the detainees who were identified by Mrs. Hingurani should be released. Continuing to detain those individuals is considered illegal and violates their fundamental rights under Article 21 of the Constitution of India, since they have been in prison for a longer amount of time than the maximum term they should have been assigned. This resulted that the release of Hussainara Khatoon along with 17 other prisoners. Aftermath. The significance of the case can be seen in the release of nearly 40,000 prisoners who were under trial after the judgment. The case prompted socially committed citizens and lawyers to express their opinions to obtain justice for the underprivileged. They utilized the extensive scope of public interest litigation. This was all about the case. Thank you so much.